This time I'd like to call to order the Campaign Finance Ethics Commission meeting of April 19th, 2013. May we have a call to the roll.
Commissioner Johnston?
Here.
Commissioner McBride?
Here.
Commissioner C?
Here. That brings us to item number 3, agenda review. And as a precursor to the agenda review, our ordinance requires that whenever a commissioner receives an ex parte communication from a party, that it be disclosed in the meeting. And so I would like to disclose that this morning I received a phone call from Mr. Steve Bennett. He was calling merely to inquire about the public comment duration and whether or not there would be any limitations placed on that. I told him I would be as liberal as possible. We discussed nothing further than the public comment duration, but I did want to disclose that communication. Under agenda review, we also have a letter filed April 16th, 2013 by Mr. Mark Lunn with voluminous attachments to it. It seems to me appropriate at this point in time to move to amend the agenda to include an additional consent agenda item to receive and file that letter and its attachments. So I will so move. Okay. Any objection?
No.
All right. Then we will add an item 8A and call it that. Any further agenda review items?
As far as ex parte communication, that's only in relationship to this meeting or any contact with parties that are involved? I'll make it easier. I have had contact with Supervisor Bennett since our last meeting, but having nothing to do with any of the subjects here.
The ordinance simply provides that any ex parte communication be disclosed and that there be no ex parte communications concerning matters which are pending before the commission. Let's see if I can find that.
No.
Really
My contact had nothing to do with the commission, just to disclose it.
That's all.
As an abundance of caution.
Great. All right. Item 4, review and approval of the meeting summary for February 22nd, 2013. I've read it.
Yeah, I've read it. So moved.
Any comments or modifications?
Is accurate?
It appears to be. Do I have a motion to approve it?
You do.
All right. Any objection? We have a motion and a second and no objection, so it is approved. Sorry, Brian. I'll try and be a little better for you. All right. Item 5, public comment. I have 2 cards for item 9 and 1 card for items 10 and 11. But do we have any public comment? I'm sorry. Was there something I missed?
No.
Okay.
No, I'm not.
Is there any public comment? We have no further cards. All right. Item 6, commission members and staff comments. Do either commissioners have any comments to make
None.
at this point in time? I'm sorry. I did have one agenda item or agenda review item that I wanted to mention, and that is that I would like to handle items 10 and 11 together, since they relate to the same settlement. Okay. Any objection?
None.
All right, item 7, consent agenda. Receive and file a report from your staff regarding the presidential general election.
Second.
All in favor? Aye. Item 8 is the fiscal report for the Ventura County Campaign Finance Ethics Commission. I've reviewed it, and it appears to be appropriate.
It's a lot of money.
A lot of money. Any other comments?
Move we receive and file.
Sorry?
Move we receive and file.
Okay, second? Hearing no, any objection? Hearing none, that is approved. All right, item 9. Good morning, Mr. Steele.
Good morning, Mr. Chairman, members of the commission. Item 9 is a recommended stipulation in case number P 2012-01. You have a complete written report in the packet, and so in the interest of time, I'll sort of distill that down. This is a case involving about 5 instances of excess contributions, most of them small and refunded to the contributors immediately upon receipt of notice of the excess amounts. Really, the significance of the case revolves around one contribution that was reported as being a $7,000 contribution. The treasurer of the committee initially reported that that had been a typo, and it was in fact a $700 contribution. In fact, upon investigation, it was a check that was written $700 in one spot on the check and $7,000 in another spot on the check. I saw the copy of the check, and it was in fact written 2 different ways. It was deposited and honored as $7,000 in error by both banks that were involved. After a pretty significant amount of back and forth between me and the campaign, the bank sort of decided the issue for us because the bank deducted $6,300 from the campaign's account, recovering that. The contributor's bank deducted that amount, so the contribution effectively ended up to be $700, although it was some months after the original contribution had been made. So the committee has stipulated to the violation and agreed to pay the fine of $700, which, to explain my reasoning in this particular instance, results in the entire amount having been sort of taken out of the election. The $6,300 was taken back by the bank, and the $700 then is the difference. And so that amount of that contribution is essentially out of the committee and out of the election process, and that's the reason that we settled on a $700 fine in this case. I'd be happy to answer any questions. We're recommending the approval of that stipulation.
Any questions? I had a couple. The information concerning the entry of the amount on the check itself in 2 different manners, I didn't see that reflected in the report. Do you know, or did you inquire about what records the treasurer investigated when she reported a typographical error?
My understanding is that she did not really report past her initial records, which indicated $700, and she just reported to the initial review attorney that the amount was a typo. She didn't go back and look at the deposit records until I actually visited the offices, at which point she had retrieved the actual deposit itself and found that it had been honored as a $7,000 deposit, and retrieved a copy of the check, which is very clearly filled out for whatever reason, $700 in one spot, 7,000 in the other. It should have been, by bank rules, honored only as 700. It's unclear why both Wells Fargo and Bank of America cashed it for $7,000.
Okay, we have a recommendation to approve the settlement. It's the pleasure of the commission.
So moved.
Second.
Any objection? Hearing none, it is approved.
Thank you.
All right. Item number 10 and 11. If we can handle those collectively.
Thank you, Mr. Chairman, members of the commission. Items 10 and 11 are proposed resolutions in two complaints, P 2012-06 and P 2012-07. 6 was filed by the Elections Division. 7 was a complaint filed by Mr. Bennett. They both relate to independent expenditures in support of Mr. Roper or in opposition to Mr. Bennett in the supervisorial election made by a group called Citizens for a Better Ventura County, which is a...
Mr. Chair, I'm sorry to interrupt, but there was 2 comment cards on item 9, I believe.
I'm sorry. Thank you, counsel. Should we await the...
Let him finish and then have a comment.
Why don't you proceed, and we'll take the public comments after your presentation.
So going back to the stipulation, what you have before you is a stipulation to resolve both cases. There were a number of independent expenditures made on a couple of different occasions. Some of those independent expenditures were not reported at all on Form 1275. Others were reported approximately 3 days late. And then there were 3 independent expenditures that, when they were reported, were improperly reported because the amounts were put on the wrong lines of forms. Cumulative totals were not provided. It was just very sloppy reporting and difficult to determine the total amounts of the expenditures that had occurred. In resolving this case, the respondents have agreed to a total fine of $8,500, admitted the violations, and agreed to file the amended reports, and we're recommending that the commission approve that stipulation in these 2 complaints.
Thank you. We'll hear next from Mr. Roper.
Good morning, Commissioners. Bob Roper, the candidate in this race. I'd like to speak a couple of things on P 2012-1. The stipulated agreement was agreed to by my treasurer, Ms. Lisa Ray, and I stand by her agreement as proposed by Mr. Still, but have a couple of suggestions for the process. One is, during the process, I, as the candidate, was responsible for hiring the treasurer, yet during the investigation I was never interviewed or contacted as far as the process goes. I understand that there was some issues about timeliness and some of the information that was given, but I would suggest that the candidate is also included in future investigations because they have control over their treasurer, and it helps streamline your process. Also, on your board agenda, on your commission's agenda, I just equate back to the way the Board of Supervisors on their standard agenda, all the stipulations are a PDF copy that the public can read. And I would just make that suggestion, if you can, is if they could be attached to your agenda in futures. Okay? That way, as we're looking at all the different cases, we can see which ones are, what consistency, or are there any issues that we'd like to bring up. And the third point is I'd just like to talk about the stipulated agreement, that I still stand in support of it. But in light of some of the legal questions that have come up by the clerk of the board about legality of fines, I would just ask you if you would consider staying the final action on the stipulated agreement until the whole wider picture, because if his case has an issue about does the board have the ability to levy fines and so forth, I would just like you to take that into consideration before any final action is done. I believe that the process is that we have to make sure is paramount in this campaign is that we make sure that every campaign is held accountable, yet we do not create any obstacles to have future candidates put their name in the ring. Thank you for your time.
Mr. Roper, let me apologize. I did have your card for item 9. I didn't take it up when we handled item 9. I apologize for my error, and we'll hear from Mr. Becker too, and then I plan to ask the commission whether they choose to vacate the decision in item number 9 and revisit it in light of the public comments. I hope that's acceptable to you, and I apologize.
That's fine. Thank you very much.
Thank you. Mr. Becker?
Good morning, Mr. Chairman, members of the Commission. As we've established in a previous meeting, I'm a former neighbor of Jim Becker, but not related. And I don't have any objection to the report and the recommendations made by the investigating attorney. I just also wanted to make a couple of observations about the process. As to the investigation itself, I'm not sure whether or not he should have, but the investigating attorney certainly didn't talk to me. But that's an aside. What I'm here as a voter, somebody who, wants to know about the candidates as far as whether or not this is somebody I want to vote for. After all, the candidates are making a pledge to each other, but to the citizens too, that they're going to live by these certain rules. I mean, they don't have to. They can stay outside the rules, and they're not bound by them as far as I understand. But either way, it's a pledge they're making to follow these rules. So it's really something that the voters ought to know about before the election happens. Now, at a previous meeting, I suggested that we shouldn't have an initial investigation that takes 30 days. And I still insist that that's correct. I mean, all we need to do is take a look. Are the facts that are alleged in the complaint reflected in the candidate's filing? If the answer to that is yes, then the next question is, if those facts are correct, would they in fact be a violation? And if the answer to that is yes, then they should move on to the investigating attorney. Now, when I talked about this last time, the commission basically said, well, we want to try to make it less expensive. We don't want to move to the investigating attorney if we don't have to and spend that money. Well, it seems to me you can just cut out that initial review attorney and have staff take a look at it. This is just a ministerial function. It doesn't have to be a legal function. And in this case, as it turned out, the initial investigation gave the commission erroneous information. Not that the initial investigator knew this, but it turned out it was incorrect. It wasn't just a clerical error as far as the $7,000 is concerned. So not only was there a delay, but the information turned out to be wrong. But from my perspective, the most important problem there is the delay. And then the next thing, when it goes to the investigating attorney, in my opinion, it shouldn't even come to this commission first and then be referred to the investigating attorney. If the staff finds that yes to both questions, therefore move it on to the attorney, then it should just go. And that person should have a relatively short time, from my perspective, to decide whether or not there is a problem here. A week or whatever makes sense, but it should be relatively short. And the campaign ought to realize that looking at the record, it looks like there's a violation. Now I'm calling you to see whether or not you have information to make me realize that there wasn't a violation. But if I don't get that information in a timely fashion, I've just got to make my recommendation that, yes, there was a violation. So it seems to me that, this could be handled in such a fashion so that it could be done and reported out prior to the election. I mean, after all, in at least two instances, the errors that were made by the campaign were corrected on October the 25th, I think it was. So it was well before the election, and that kind of information could have been made known to the public in various ways. And as I say, I know that this commission doesn't write the rules. On the other hand, I know this commission is appointed by the board and therefore has some influence with the board, and that's why I make the observations and remarks that I've made here, hoping that you'll think about them and maybe in some way it'll influence your thinking about what is a sensible process and make some recommendation to help speed up the process so that we as voters will know what the result is prior to the election, if possible. Thank you very much.
Thank you for your comments. Now I would like to ask my fellow commissioners whether or not...
One more speaker, Mr. Chair. Mr. Bennett.
Simon, number 9. Mr. Bennett.
Thank you very much for this opportunity, and I appreciate there are multiple issues today, and they sort of intertwine as we go amongst the agenda items. I'd just like to start by emphasizing that the Board of Supervisors is most interested in trying to carry out the public's desire to decrease the influence of money in politics. And that was the goal of creating the ordinance. One of the primary objectives of decreasing the influence of money in politics is to make sure that that money is clearly reported, the expenditure of that money is clearly reported to the citizens before the election actually takes place. And the stipulated settlement that you have here in front of you regarding this particular settlement, the $700, I have no qualms about that, and I certainly would support that. But I would like to point something out, and that is that the campaign, the committee, was informed well before the election that they had this error, the $7,000 error. And what they left out there for the public was the perception that it was just a typographical error, that they had just added an extra zero on the report, when in reality they had actually made an error that was more egregious than that. They had accepted a contribution for $7,000. It reflected as a $7,000 increase in their bank account, and that was not corrected until after the election. And I would offer to you that traditionally in these campaign finance enforcement issues, there is a significant difference between correcting your error and getting it all straight before the election versus cooperation after the election. Cooperation and compliance after the election comes at very little political cost in terms of the election, but disadvantages the public. And in this situation, I would suggest that, number one, the idea that you should hold this until later, the later issues have nothing to do with the right of the commission to actually fine a committee for a violation. But I would suggest that you also add at least verbal comments that the commission wants to emphasize that when an error is made, and the ordinance, I think, is very flexible about errors being made. We all know it's going to happen. But when an error is made and it is pointed out to a committee, that a committee has a responsibility, as Mr. Becker identified, to promptly get that fixed so the public has accurate information. In this situation, that did not happen. And the question of negligence versus an oversight and an error, when you have been informed and you've been contacted by the investigating attorney that you have listed $7,000 on your report, and you don't do two things. One, promptly investigate that thoroughly to find out what happened, but instead just say, we just added an extra zero there. If you don't do that, there should be a consequence for that. And second, you actually should file an amended return to fix that return that was in error promptly. That did not happen promptly in this situation before the election. So it just would ask the Commission to strongly consider that also, because for us to accomplish the original goal that I identified, decrease the influence of money in politics, we all have a role to play. And one of the roles is for the Commission to try to encourage not prompt cooperation and compliance after the election, but prompt compliance and cooperation before the election so that we get this accurate information in as broad a form as possible to the public so as they get ready to make their decisions. Thank you very much.
Thank you. I would like to move to vacate the prior board action in item number 9 to allow any discussion, if there is any, of the public speakers that I erroneously did not hear from prior to taking the action. Is there a second?
Need a motion on that, or you just want
I'd be more comfortable with a motion.
to just open up the discussion? Sure.
Right, so we have vacated our decision in item number 9 presently. Oh, is there any objection to that motion? Hearing none. It is vacated. I do this out of an abundance of caution because of my error in failing to hear from the public at the appropriate time. Is there any comment or further questions from the Commission as a result of hearing the testimony of the 3 public speakers speaking to item number 9? Anything? Okay.
I'm good.
Do I have a new motion for item number 9? The recommended action is to approve the stipulation.
Move the recommended action.
Second. Any objection? Okay. I apologize again. Now, we have item numbers 10 and 11. Did I have a speaker card on that?
Mr. Chairman, if I may, just before you call the speaker on 10 and 11, I neglected one piece of information
Oh,
that
good.
may come up in your public comment. As Mr. Roper asked that the commission delay decision until you decide number 13, I don't know whether the respondent in 10 and 11 is here. I did receive a phone call yesterday from one of the members of this committee asking the same thing, that whether this decision could be put off until after you decide item 13. I informed the respondent that the issues in item 13 have nothing to do with the Commission's broad authority to levy fines in cases not involving an employee of the county or an official of the county. And so I informed the respondents that I was not inclined to go along with a delay in the Commission's decision, but that would be up to you, and that I would convey that request to you. So I am conveying that request to you, but I did inform the respondent that in my opinion, the 2 issues are completely separate, and item 13 has nothing to do with the fine in 9 and 10, in 10 and 11.
Good. I do have a public speaker card on 10 and 11. John Hecht.
Good morning, members of the commission. Excuse me. Thank you for allowing me some time today. Here today speaking on behalf of Citizens for Better Ventura County. First comment is that we or I have not been following this matter closely. We hired a professional treasurer who we relied on to do the compliance with the ordinance in this matter. Not here to dispute her stipulations. She has agreed to those, and she is cognizant of the facts of those. But I am here to make the same request that Mr. Roper did, that the commission continue final action on these until the issues in item 13 have been resolved. I briefly looked at the packet, but I'm not an attorney. I'm an engineer. And in the engineering world, even in the engineering world, where we think of things as black and white, two experts can disagree on something. That's very surprisingly common. In the legal world, I've been in enough legal proceedings that very smart, very competent, very good attorneys disagree frequently, and it's often resolved. One has to win, one has to lose. So in this case, while I did speak with Mr. Steele yesterday, and I completely understand his position, there very well may be in a legal position that says that there is a relationship between the fines levied here and the issues raised in agenda item 13. So given that that is always a possibility, that we have no intention of withdrawing the stipulation, that the money has been issued, I see no harm in continuing these items for until that issue is resolved, and I would respectfully make that request of the commission. Thank you.
Thank you for your comments. Just hear from staff.
Is that all?
Yep.
Well, I don't think there's a relationship, but I have no problem taking item the item 13, the 9:45 time certain first. We'll have to take a break for 10 minutes to hear that, and then come back to these items. But I don't really know if that's necessary. But we have a request.
We have an item 12 we could handle during the interim.
Okay.
All right, then let's delay hearing items 10 and 11 until after the 9:45 hearing on number 13. Is that agreeable?
We should treat item 12 the same way, shouldn't we?
I'm sorry?
Should treat item 12 the same.
Item 12 involves different parties and different issues.
Associated with
Yep. All right. The commission will take a 10-minute recess until the beginning of the 9:45 time certain matter. Item number 13. I'm sorry? I'm sorry. I'm calling this meeting of the Campaign Finance Ethics Commission back to order. It is 9:45, and we'll proceed with the hearing on item number 13. I have two speaker cards on item, I only have one speaker card on item 13. So we'll hear from Mr. Bennett first.
Thank you very much. Again, I'd like to emphasize that the goal of the ordinance is to try to decrease the influence of money in politics. For that to happen, we have to have prompt compliance and cooperation before the election to take place, as I mentioned earlier. And for that to happen, the clerk has some basic duties that must be performed for that compliance to take place, for the public to have the broadest possible knowledge of where the money is coming from. So it is an essential role of the campaign ordinance and most local campaign ordinance. The clerk has duties identified. And in fact, as you saw in the report, the Fair Political Practice Commission sometimes has actually taken action when duties were not handled properly by a party who had that responsibility. Now, I'm not here because I want the clerk to be fined. I'm not here because I want anything to necessarily. I want to make sure that in the future this doesn't happen again. In the future, we are sure that the public gets informed when they should get informed. And the duties that we are asking of the clerk are very basic. In fact, 2 meetings ago when I was here, some of the commissioners expressed a concern that the clerk may have to review every form that comes in. And I want to point out to the commissioners that state law already requires the clerk to review every form that comes in, and we copied the exact same language, which says on its face, has the form been filed properly? And on its face, the clerk would then therefore know the things that the clerk was supposed to know in this situation. So the other thing is there's this reference that the ordinance would increase the responsibilities. And I would point out that in the last election, there was only one competitive race where there would be these filings that would be intense. There was only one competitive race that the clerk even had to monitor, and that was the Board of Supervisors race in District 1. There were no other contested county races in that November election at that point in time. So we're talking about one race, certainly in a relatively small number of forms. So we have not asked anything unusual or anything extraordinary of the clerk with this. While the clerk's office and has found technicalities for why they should be, why none of the complaints should be upheld, I would offer to you that the bottom line is the clerk's office did not review the forms on their face to see if they complied. The clerk's office did not promptly notify the opposing candidates when the clerk was aware of an independent expenditure of $1,000 or more. And the one remaining complaint that you still have the possibility of taking action on, that nobody's been able to find sort of a technicality on, is that the clerk did not follow the ordinance that says within 24 hours they should cause to be electronically posted a filing when a committee has spent more than $10,000. Now, the clerk doesn't contend that any of those facts are false. The clerk doesn't contend that they did notify the candidate the committee within 24 hours they were supposed to file. The clerk acknowledges they didn't do that until after the election. Much of what the clerk did here in compliance took place after the election. And that is... and there's a huge difference, and I think it's really important that the commission make a big distinction between actions taken before the election promptly for the benefit of the public and actions taken after the election when everybody has an incentive to be viewed as cooperative and trying to comply. Because as much as we can sit here and we will always hear from the people that don't comply, I didn't know, it was too confusing, I didn't understand. The bottom line is we have a basic responsibility to read the ordinance, and the language is pretty darn clear on most of these things, that you need to not take more than $700. If you read any one section, it is certainly clear. So you have, I think, a number of issues in front of you. The Board of Supervisors is going to have some issues in front of us. We have the issue of what are we going to do as we every 2 years review our ordinance. I believe that the opinion of the objective attorney hired by County Council went outside, did not hire an attorney that had a dog in this fight one way or the other, and got an objective opinion that said, yes, the clerk does have duties that can be assigned here. And certainly we'd make it clear that we don't want the clerk's office to be fined, but we do want to have the clerk's office at least be notified that the commission thinks they should do this in the future. And I hope that as you work to try to resolve this, that you don't take any action that would imply or decrease the ability for all of us to try to make sure that there is good compliance before the election takes place. Finally, I would offer you this. We've had considerable amount of money spent on attorneys with this. One attorney, as I pointed out, with an objective point of view, another attorney hired by one of the parties in this race. Certainly the Board of Supervisors has not gone out and hired an attorney with a particular point of view to get involved in this, nor have I as the complainant in this thing. But I think we should ask ourselves from a big picture, what do we want our clerk and the clerk's office, what do we want their position to be? I would offer to you that it's in the public's interest for the clerk's office to take the position like the Secretary of State took in the California election, where the Secretary of State proactively and assertively went out and tried to force the disclosure of where the Arizona money was coming from, the $8 million in expenditures. That we didn't want the Secretary of State to in that situation say, hey, that's not my job. I don't have that responsibility. I'm not technically responsible for that. We don't want the clerk to say, I can't do that because I have to do the important job of running the election. I would offer to you that contention that informing the public of where the money is coming from should be part and parcel of the important task of running the election. And so I hope that the Commission will not take action that would make it more difficult for the future. And that's really what this is about in my mind at this point in time, is for the future to make sure that we do have good compliance and that the clerk does perform the basic duties that are both assigned by this ordinance and also assigned by state government and state law, which is that the clerk needs to review those forms, and when they have that information, be able to move forward with that. The very final thing I would point out to you is it is very difficult to construct effective campaign contribution limit laws in light of all of the court rulings that are out there. And the Board of Supervisors has no intention of creating anything more difficult or more confusing than possible, because we know that is an argument that's used. We spent tons of hours working with County Counsel's office to craft this ordinance over the last 10 years and to revise this ordinance over the last 10 years to try to make it work. One of the key components of the ordinance is this idea that the only way you can get people to limit their campaign expenditures is to make it voluntary, and make it voluntary contingent upon somebody else, and people won't agree to that if somebody else can dump an enormous amount of money in at the last minute and overwhelm them in that situation. And that's why we have that very delicate issue in there of making sure we monitor the independent expenditures so that that candidate knows when that threshold has been exceeded, and that candidate then is released from that. Now, that is a delicate balance that requires good faith efforts on the part of everybody. And that's the Board of Supervisors when they write the ordinance, the clerk when they follow the duties that are there, and the Commission when they try to interpret this, to try to make sure we hold on to that delicate balance as we move forward. I wish it was easier. I wish the courts made it easier, but that is what we have, and it does require all of us to have a certain amount of responsibility to move forward. So again, not looking for penalties, we're looking for compliance, and hope that there is direction by this Commission to the clerk to make sure that they do take these actions in the future. Thank you very much. I appreciate it.
Thank you for your comments. All right, I guess the next person to be heard from is Mr. Wucher.
Good morning.
Good morning.
I didn't know how you'd like to proceed. I've obviously prepared a written opinion for you a while back. It lays out my independent thinking. I don't profess to have be able to bring anything to this other than the research that I was able to do and the experience, and to the extent I've developed any expertise in this area just over the years dealing with these issues. But as I've been the first to say, it's a very complicated issue. It's an ordinance that I don't think this question was necessarily ever raised before and addressed explicitly as one might like in the ordinance, and it's an issue that had not arisen in other contexts very frequently. So I think just to put a little gloss on what I did provide you in writing, and I'll be more than happy to respond to anything, and I can address a couple of the issues from Mr. Guilford's presentation as well. I will confess that when I first looked at this, I was leaning, based upon my own understanding of how the systems had worked and my reading of the ordinance and my knowledge of how the principal objectives of most of these ordinances that exist throughout the local jurisdictions, I was leaning towards a position that said, well, yeah, the clerk may have duties, but that's not really something that's subject to enforcement under the provisions of the ordinance. They're kind of different duties than those of candidates and others that would be the primary objective of it. The thing that was most compelling to me, frankly, is the precedent set by the interpretation given by the Fair Political Practices Commission to very similar language under a really similar scheme under state law. In which they have taken the position and have taken several enforcement actions pursuant to that position and have gotten people to agree to pay very substantial fines with respect to those, taking the position that the obligations of filing officers, which the clerk is here, and the duties that I pointed out, the duties that are set forth for the county clerk here are almost identical and seem to be taken verbatim from the Political Reform Act duties for local filing officers under the Political Reform Act, and that they have concluded that, yes, those are duties that are also enforceable through administrative proceedings by the Fair Political Practices Commission. And I found that to be a fairly compelling piece of evidence, given that it is so clear from the legislative history here and from the explicit text of the local ordinance that it was modeled upon and intended to be essentially a local counterpart for the statewide ordinance. So that is really, to me, the most significant piece of evidence, in addition to the actual language, and to the absence of anything, as I point out, that would suggest that the clerk's duties are not enforceable by the commission or not subject to the jurisdiction of the commission. I do think it's and I don't think, I gather nobody is disputing from what I'm hearing and the other comments I've received, that clearly that the duties are directed to the office of the clerk and not the clerk individually. I think that's quite clear both from the language of the ordinance, from general principles of governmental immunity and the responsibilities of it. And just as a practical matter, it's clear that it is not intended that the county clerk as an individual be either responsible for performing all these duties himself, or herself, as the case may ever be, and that the liability does not attach personally. So I think that question is pretty clear. With respect to the issue of what penalties may be imposed if a violation were to be found, as I say, I do think that there is some, frankly, some interrelationship between some of the arguments that Mr. Guilford made in his submission on behalf of the county clerk and those that I had made, in which I had suggested that it was not a reasonable interpretation of the board's intent to suggest that this commission would have the authority to fine the county clerk's office if in the event of a finding of a violation. I do think that is something that, as I point out, is not directly flowing from the language of the ordinance, which doesn't necessarily preclude that, but I think it is something that flows not only from, I believe, the intent of it, but the very structure of county government and the budgeting process for county government, and, as Mr. Guilford points out, the relationship between this board as an administrative agency of the Board of Supervisors, this commission as an administrative agency of the Board of Supervisors, and its ultimate authority vis-a-vis the remainder of county offices and kind of things. Now, I just would comment briefly upon the submission Mr. Guilford made. He makes what I believe is a rather stretched argument suggesting that because violator in one section of the Political Reform Act that doesn't really relate to anything here also uses the term person, that violator in the local ordinance must mean person, and even though there's no definition of person in the local ordinance, there's a definition of person in the Political Reform Act, and the Political Reform Act definition of person does not appear to include a county official. Therefore, violator can only be an actual individual, and it can't be a county official. I think that is, with respect, more advocacy than independent analysis. I think that it is clear by the actions of the Commission and by the rest of the structure of the Political Reform Act that, in fact, the Fair Political Practice Commission does have jurisdiction over local officials, government officials, and so the definition of person is not really the appropriate hallmark to be using in terms of determining what the scope of this commission's jurisdiction is, and it is certainly not in any way equivalent to violator. There's nothing in this ordinance and the language of the ordinance or legislative history that suggests in any way that a violator has to be a person. And the absence of any such language, I think, is compelling in and of itself. I would also like to, I guess, briefly address my disagreement with what I believe is a fairly, I gather, sort of a, I don't want to say radical, but a step up in defensive arguments here, suggesting that the Commission does not have the authority to impose a fine because it would be beyond the Commission's authority as an administrative body. In fact, if you look at the Attorney General opinion, which is not really a formal opinion, but is, in some senses, you kind of read between the lines, it's one law enforcement official sending a letter to another law enforcement official saying, hey, don't worry, we got your back if it gets too bad here. But that opinion, to the extent it has any real bearing, makes it clear that, in fact, the ordinance is valid and the Commission does have a legitimate role to play, and that, in fact, there's no problem with the Board of Supervisors delegating to an administrative body like the Commission the authority to take all these actions as long as there is sufficient oversight. It's kind of the the two caveats there were there needs to be sufficient oversight from the board ultimately, and it cannot intrude upon the independent functions, which are statutory in nature from state law, of the district attorney's office. Well, there's no question about the latter here, and that was really the focus, I believe, of the letter and the opinion. But with respect to that second oversight, I will point out that there is substantial oversight here. I mean, not only has the board adopted the ordinance, which created the law, created the Commission, it has approved the procedures, explicitly approved the procedures that under which this Commission operates. It has appointment power, it has removal power, and it requires that the Commission periodically report back to the board about its activities. So there is substantial oversight. I don't think there's any doubt that this Commission is constitutionally authorized to impose fines. The real danger, of course, from the argument, and you've heard it now from people suggesting, well, why don't you wait and conclude this matter before you take on our matter, is that it suggests that the board not only doesn't have the authority to fine the county clerk, it suggests that the board doesn't have the authority to impose any fines on anybody, which would, of course, essentially, make the Commission void of any kind of meaningful enforcement authority. And it suggests that not just this Commission, this administrative agency, but any of the administrative agencies that would be appointed by the Board of Supervisors wouldn't have the authority to make determinations on business taxes that are owed, and code enforcement issues couldn't levy fines. So I think it's just an argument that goes way, way too far. It's not all supported by the authorities, and in fact, it's contrary to the authority that's really relied upon by in that Attorney General opinion. So with that, I will conclude my remarks. As I say, I'm more than happy to answer any questions you have, and anything I can do. I don't envy you for the tricky legal issues that you're confronting here, but I do think that if you follow traditional rules of statutory interpretation and particularly look at the objectives of the ordinance and the both historical and practical impact of the FPPC's precedents in this area. I think the conclusion results that the commission does have authority over the county clerk's office if there are violations of the county clerk's office's duties under the ordinance, and that the commission has the authority to order the actions to be taken to comply with the ordinance. So, thank you.
Thank you. Do you want to ask any questions of Mr. Wuscher at this time, or do you want to hold them until we've heard from Mr. Guilford?
I'll wait.
All right. Thank you, Mr. Wuscher. Mr. Guilford?
Good morning, Mr. Chairman and members of the Commission. Thank you for the opportunity to address the Commission on this matter. There are two preliminary comments that I'd like to make before turning to the issue of jurisdiction, if I may. The first is in response to Mr. Bennett's comments. The office of the clerk and the employees of that office faithfully and diligently perform their duties and obligations under this ordinance. But that's not the question before us today. The question is the issue of jurisdiction, which I'll turn to in a moment. The second preliminary matter that I'd like to address is it's undisputed at this point, even by complainant, that Mr. Lunn, in his individual capacity, is not properly the subject of a complaint under this ordinance. Because the complaint is only stated against Mr. Lunn in his individual capacity, an issue that has been out there for several months now, it's been made clear that this complaint is solely against Mr. Lunn in his individual capacity. And because there has been no request to amend the complaint to name the office of the clerk, we respectfully submit that the complaint should be dismissed in its entirety at this time. We made a motion to dismiss the complaint in our April 5 brief, pursuant to Section 13.05 of the Commission's operating policies, but did not receive a response to that motion. So we submit that the complaint should be dismissed. With respect to the issue of jurisdiction, it is our view that the Commission does not have jurisdiction over complaints against the office of the clerk for alleged violations of the ordinance, and that the Commission does not have the authority to impose a penalty or other remedy against the office of the clerk. And we are of that view for several reasons, as we laid out in our April 5 brief, and I'm happy to walk through those reasons with the Commission and to respond to Mr. Wuscher's very fine analysis, or if the Commission would prefer, I can respond to questions, however you would like me to proceed.
Which pleasure.
I'd like to hear from him.
I will walk through the reasons. Thank you.
Thank you.
We believe that there is no jurisdiction of the Commission over the office of the clerk pursuant to the express language of the ordinance. Section 1297I of the ordinance provides that the Commission has the right to impose certain penalties or remedies against a violator, quote, violator of the ordinance. So the question then turns on, what does violator mean? Pursuant to Section 1263 of the ordinance, you have to look to the Political Reform Act for the meaning of the term violator, because violator is not defined by the ordinance. As we laid out in our April 5 brief, the term violator is synonymous with the term person. Pursuant to Section 83115.5 of the Political Reform Act, there's simply no disputing that violator must mean the same thing as person. Otherwise, 83115.5 is entirely nonsensical. With all due respect to Mr. Wuscher, that's no stretched argument. It is simply a fact that those terms are synonymous. The term person is not defined by the ordinance. Again, pursuant to Section 1263 of the ordinance, we need to look to the Political Reform Act. What does the term person mean? And under 82047, there's a definition of the term person. And the person does not include, the term person does not include the office of the clerk. In fact, clerk is specifically defined by the Political Reform Act. The ordinance specifically requires that one look to the Political Reform Act for the definition of terms unless those terms are defined by the ordinance itself. Because violator is not defined by the ordinance itself, we look to the Political Reform Act. It means the same thing as person. Person does not include the office of the clerk, and we respectfully submit that the express language of the ordinance therefore means that when the term violator is used, it cannot, as a matter of statutory construction, include the office of the clerk. We believe that the notion that the office of the clerk is not considered a person under the ordinance is further demonstrated by reviewing the legislative history of this ordinance. Ordinance number 4280, which was adopted in March of 2003, added for the first time a penalty section at 1294. And section 1294A of ordinance number 4280 provided that any person who knowingly and willfully violates this ordinance is guilty of a misdemeanor. And it's not qualified in any respect. Any person is guilty of a crime for the knowing and willful violation of the ordinance. And we're not aware of any authority that holds that a governmental office, as opposed to an individual, can be responsible for a crime for having violated the ordinance. And ordinance number 4280, or any subsequent iteration of the ordinance that included this misdemeanor language, does not reflect that it was contemplated that the office of the clerk could be responsible for a crime for a knowing or willful violation of the ordinance. The fact that section 1294A of ordinance number 4280 provided in mandatory terms that any person is guilty of a crime further establishes that it was never intended that the office of the clerk would be considered a person under the ordinance. And if it is not a person, it cannot be a violator of ordinance number 4429. We also believe that as a third step in statutory construction, looking to the practical aspect of a statutory construction, that it must be that it's required that the commission determine that there is no jurisdiction in this matter. A practical construction, or any proposed construction of a statute, must not lead to absurd or unintended results. Statutory interpretation requires the application of reason, practicality, and common sense. We respectfully submit that reading the ordinance to provide the commission with jurisdiction over complaints that someone violated the ordinance in their efforts to discharge their obligations under the ordinance leads to absurd and unintended results. We acknowledge that the ordinance imposes obligations on the clerk. It imposes obligations on others, including the initial complaint review attorney, the investigating attorney, the clerk of the commission, county council, and the commission itself. So if the ordinance authorizes one to make a complaint against the clerk's office for allegedly failing to discharge obligations under the ordinance, then the commission would have jurisdiction over complaints that all of those who have duties under the ordinance can be brought before this commission on an allegation that they did not properly discharge those obligations. For example, and we laid out several examples in our April 5 brief, and I promise not to repeat them all here, but as an example, the initial complaint review attorney is charged with the obligation of reporting back to the commission within 30 days after receiving an initial complaint. The commission has an obligation to report back to the Board of Supervisors. If the initial complaint review attorney fails to fulfill that function, or if the commission fails to timely report back to the Board of Supervisors, may a resident of Ventura County file a complaint that says that the ordinance itself has been violated by the failure to perform those functions that are delegated to those individuals under the ordinance. We respectfully submit that once you determine that those who are charged with implementing and enforcing the ordinance are subject to complaints for violating the ordinance itself, it leads to these absurd result that would end up with the initial complaint review attorney having to be replaced by another initial complaint review attorney to review the complaint that was filed against the first initial complaint review attorney, and so on, as laid out in our April 5 brief. On the other hand, there are no such unintended consequences when the ordinance is read not to provide jurisdiction in the commission over complaints against those who are charged with implementing and enforcing the ordinance. An aggrieved party has a readily available remedy in mandamus. Mandamus is the traditional method by which one seeks to compel a public official or agency to discharge a legal duty. We believe, and we respectfully submit to the Commission, that the express language of the ordinance, the legislative history, as well as the application of the ordinance itself all dictate that the Commission does not have jurisdiction and does not have the authority to impose a penalty or other remedy against the office of the clerk. But there's an additional reason why, in our view, the Commission does not have the authority to impose a penalty or remedy against the office of the clerk. Mr. Wucher addressed this point with respect to Government Code Section 31000.1, which provides that the Board of Supervisors may appoint a commission, and the commission has the authority to make reports and recommendations to the board. The ordinance here purports to vest in the commission authorities that exceed those that may be conferred upon the commission pursuant to Government Code Section 31000.1. Section 1297I of the ordinance authorizes the commission to impose penalty or remedies as opposed to making recommendations to the Board of Supervisors for purposes of effectuating those penalty or remedies. Mr. Wucher made reference to code enforcement authorities. Those matters usually have a right of appeal to the Board of Supervisors. In this circumstance, there is no right of appeal to the Board of Supervisors. It's straight to the judicial remedy. I can't speak with respect to all other enforcement schemes. I'm simply not prepared to do that. However, each one would have to be looked at individually, and in this circumstance, where there is no right to go to the Board of Supervisors with respect to any penalty or other remedy that may be levied, we submit that it exceeds the powers that may be conferred on a commission pursuant to Government Code Section 31000.1. And in fact, we read the Attorney General's opinion as supporting that construction of the ordinance. The Attorney General's office said that the commission may properly be appointed, certainly it said that, but that there needs to be sufficient board oversight. In reviewing the immediately preceding ordinance 4414, which has identical language at Section 1297I, the Office of the Attorney General said that there is not sufficient board oversight with respect to that provision of the ordinance. So we respectfully disagree with Mr. Wucher's reading of the opinion of the Office of the Attorney General. Finally, as an overarching issue, vesting jurisdiction in the commission to oversee the office of the clerk and its performance of its functions under this ordinance places the commission in essentially a quasi-judicial role over the elected clerk and the office of the clerk, as well as the exercise of the elected clerk's ministerial and discretionary duties as the head of the office of the clerk. We submit that even if there is an argument for jurisdiction, and we respectfully submit that there is not here, that the commission should decline to exercise such jurisdiction over that elected office, because it would place the commission in this role of having essentially a veto power in the form of a cease and desist order or an order to undertake certain affirmative acts that runs afoul of the separation between the clerk's office and the role of this commission, as well as the role of the judiciary in overseeing the clerk's performance of its obligations under the ordinance. As I said before, mandamus is that's the province of mandamus for the judiciary to make the determination of whether or not the clerk has properly performed a legal duty. Thank you to the commission for your time.
Thank you. All right, well, I have some questions. I assume other commissioners do as well. Maybe I can just start. Mr. Guilford, in connection with your argument that the ordinance is invalid because it lacks proper oversight by the Board of Supervisors, you were present during the presentation of Mr. Wucher. Do you disagree with his conclusion that the oversight in adopting the ordinance and amending the ordinance is necessary, adopting the rules of procedure and amending the rules of procedure as necessary, and the powers of appointment and removal of commissioners themselves, and the existence of a judicial remedy are inadequate oversight for the ordinance by the board?
Well, we don't make the contention that it's inadequate oversight for the ordinance. We make the contention that it's inadequate oversight for a circumstance where the commission seeks to impose a remedy, a fine, or other remedy against an alleged violator. And the reason for that is because there is no ability of that alleged violator to bring the matter to the Board of Supervisors. The commission is vested with the full and final authority on that, and with all due respect, we believe that the Board of Supervisors must retain that authority with respect to that issue.
Two questions. One, the Board of Supervisors did not bestow that discretion entirely upon the commission. They limited it. They limited it by providing that the fine can't exceed a certain amount or a multiple of another amount. Why isn't that adequate supervision of the delegation of its authority over the fines?
Mr. Chairman, with all due respect, I believe it's inadequate authority because for two reasons. Number one, the person that receives that fine, and in this case, if it were the office of the clerk, although there's a concession that a monetary penalty cannot be imposed against the office of the clerk, which is another reason, actually, why the ordinance cannot be read for there to be jurisdiction over the office, which I'd be happy to discuss in a moment. The person that is fined has no ability to appeal that determination to the Board of Supervisors. And so in that respect, we believe it's inadequate oversight authority. The second issue is, although the Commission's jurisdiction in terms of imposing penalties or remedies is limited with respect to fines, it's not limited with respect to the issuance of a cease and desist order or the ability of the Commission to order essentially what's a mandatory injunction in the form of requiring a alleged violator to undertake a certain affirmative act.
Well, the issuance of an order to pay a fine is one of the various remedies under the ordinance. I can think of many, for example, criminal statutes, which apply to various entities and individuals, thinking of the violation of the Sherman Act, Antitrust Act, and things like that. It's clear that a corporation may violate some of those statutes, and a corporation cannot be jailed or imprisoned which is one of the potential remedies under those acts? Does the fact that a particular entity or individual is not subject to all of the remedies that are provided for in the act invalidate the act?
Depending upon the circumstances, Mr. Chairman, in this circumstance, with respect to the concession that monetary penalties would not apply against the office of the clerk under 1297I3, we believe that principles of statutory construction, which require that the commission seek to harmonize all the provisions, necessitates reading the ordinance to mean that the commission does not have jurisdiction over the office of the clerk, as opposed to simply reading out that language because it conflicts with other language of the ordinance. The first role, the first step in statutory construction is to seek to harmonize all the provisions. And the provisions may be harmonized by reading the ordinance not to confer jurisdiction over the office of the clerk. And there are other reasons why that result is dictated, in our view.
In your brief, you maintain that the office of the clerk is not a person within the meaning of violator, and you cite various PRA language to that effect. But you ignore part of the language of the material you quote, which applies the term person and ergo violator to any limited liability company, association, committee, and any other organization, the clerk's office, or group of persons acting in concert, arguably the clerk's office. Isn't the identity of the doesn't the ordinance apply to a variety of different entities? And is there any reason to single out the clerk's office, one who has a series of ministerial duties created by the ordinance, from the rest of the entities subject to the ordinance?
There are two reasons why the answer to that is yes. There is a reason not to include the clerk, the office of the clerk. Number one is, with all due respect, I don't believe we ignored that catch-all language of the definition of person. What we pointed out is that there is a definition, a specific definition of clerk under the Political Reform Act, and that in a circumstance where there is a general catch-all language and specific language, arguably addressing the same topic, statutory construction requires that you defer to the specific language. So if the term person was meant to include the term clerk, then it would have been so defined, but it did not. It separately defined the clerk. The second issue, Mr. Chairman, is there a reason to exclude the office of the clerk, even though the office of the clerk has duties under this ordinance, from jurisdiction of the commission? And there are several reasons, and we've laid them out in our brief, but one of the most compelling of those is that if the office of the clerk is subject to a complaint that it violated the ordinance itself by failing to properly discharge a responsibility, then so too are all of the others who have duties under that ordinance, including the commission itself. And we simply do not believe it was the intention to subject those who are implementing the ordinance to complaints for violation of the ordinance itself. That is the province of mandamus. And if I may, I'm sorry, Mr. Chairman, one further point. We don't seek to exclude the office of the clerk. We seek to make clear that those responsible, like the employees of the office of the clerk, for discharging responsibilities under the ordinance, including the initial complaint review attorney, the investigating attorney, and the clerk of the commission, and others, we simply seek to make clear that those persons or entities or individuals cannot properly be held to a complaint for violating the ordinance itself.
You know, I suppose we can get into a discussion about mandamus and the adequacy of remedies associated with that. it seems to me that the parade of horribles that you present of requiring the complaint review attorney to act right or wrong, and the review attorney, likewise, the duties enjoined upon him, involve very discretionary acts. And mandamus won't lie to compel a particular result, but will only compel exercise of the discretion. The acts that we're concerned with in this ordinance are really clear, present ministerial acts. None of the complaints that we have dealt with or have left to deal with today deal with anything but a ministerial act provided for by the ordinance, and if violated, enforceable by the sanctions.
Mr. Chairman, some of the duties that we alluded to within our brief are discretionary, but there are others that are not. For example, the requirement that the initial complaint review attorney report within 30 days, a ministerial task. Same with the investigating attorney, and there are other functions that are discharged by others under this ordinance that would fall into the category of ministerial. And we simply submit that there is a remedy available to those who are aggrieved. There is a remedy available by mandamus to Mr. Bennett. But the proper remedy is not for a complaint that the ordinance itself was violated. By way of analogy, when the Planning Commission acts and it's then approved by the Board of Supervisors, there may be remedies in the form of mandamus, but the Planning Commission doesn't get sued for violating the building code. They go to the building code itself. They go to court, to the judiciary, which discharges its functions under mandamus.
What is the applicability, in your opinion, of Section 1294 Subdivision D of the ordinance, which provides before filing a civil action, and an action in mandamus is a civil action, does it not?
Yes, Mr. Chairman.
For any violation of this ordinance, any person must first ask the Commission to file such action pursuant to the terms of this section. If the Commission fails to file an administrative action within 60 days of receipt upon such a request, then the requesting person may file an administrative action in his or her own name. C of that section says no civil action alleging a violation for this ordinance may be filed by a person if the Commission has filed an administrative action. The intent of the ordinance appears to be clear, that the remedy of mandamus is not readily available if it's otherwise covered by the ordinance.
Well, there may be circumstances where a complaint is covered by the ordinance. This is simply not one of those circumstances, we respectfully submit, since the complaint is brought against an office that is seeking to discharge responsibilities under the ordinance itself. So perhaps these sections have applications, and I can see how they would have application in certain circumstances. In this circumstance, we are in a bit of uncharted water, as Mr. Woodger acknowledged.
Those are my questions this time.
Those were my questions too, at least some of them.
Well, ask the rest of them then.
Well, I'm just curious, going back to section, the government code section 31,000.1. Are you indicating that in order for any action of this, in order for the ordinance to be valid, that there must be an appeal process of all matters that come before the board, appeal process to the Board of Supervisors?
Thank you, Commissioner McBride. We don't extend the argument that far simply because it would be difficult for me to envision, and I don't have a basis on which to envision all matters that may come before the Commission. In this limited circumstance, where the Commission is questioning whether or not there's jurisdiction to impose a remedy of some form, including a cease and desist order, perhaps against the office of the clerk. In that circumstance, we strenuously argue that the commission does not have that authority in light of Government Code Section 31,000.1, and that there must be a right to go to the Board of Supervisors for the board to retain ultimate oversight authority, as it must, and as the Office of the Attorney General noted, it had not.
It's interesting, the opinion that you cite, the letter opinion to District Attorney Greg Totten indicates that they find the authority to create the commission and for the commission to institute fines and so forth. They were presented with the same question and yet didn't go as far as you do by saying, but since the ordinance does not contain an appeal to the Board of Supervisors, there has been an illegal delegation of authority.
Well, I respectfully disagree, Mr. Chairman, and if I may read from the opinion of the Office of the Attorney General at page 3, last paragraph. Again, in the context of ordinance number 4414, the preceding ordinance to 4429, but dealing with identical language at section 1297I, what the Office of the Attorney General said is, quote, here, the ordinance that you have brought to our attention does not include provisions addressing either the Board of Supervisors' oversight of the Commission's activities or, and then it goes on to address matters relating to the district attorney. So we believe that the Office of the Attorney General did speak to this very issue, citing Government Code Section 31,000.1, and made clear that this ordinance, again, identical language, does not include sufficient oversight. And presumably the notion is that there must be a right of appeal to the Board of Supervisors for there to be sufficient oversight. But we believe the Office of the Attorney General did answer that question.
Do you place any significance on the fact that the opinion was requested by a district attorney who was clearly in his letter concerned with the inroads into his prosecutorial discretion that the ordinance might occasion?
I don't...
Which language disappeared from the ordinance when they eliminated the misdemeanor provisions?
Correct. Noting that the Office of the Attorney General did not limit itself to the issues relating to the district attorney, and I do not question the disinterestedness of the Office of the Attorney General in reviewing this ordinance.
Kind of following up on this 31,000 section. If the board were to amend the ordinance to specifically provide that the commission had jurisdiction over the clerk and provided an appeal process, would, in your view, would that give this commission jurisdiction to act in a manner that is proposed here?
I believe there would be some issues relating to potential conflicts with the Political Reform Act and Section 1263 of the ordinance, which makes clear that the ordinance is preempted by the Political Reform Act. However, I would note that that's not the circumstance here today. In fact, the authority given to the FPPC is broader than that given to the commission here under 83-115, which makes clear that the the Fair Political Practices Commission has the authority to investigate violations relating to agency or official or other action, language that is not found in this ordinance.
So you feel that it's outside the power of the Board of Supervisors to give this commission the authority to jurisdiction over the county clerk?
Commissioner McBride, I'm going to have to respectfully defer because I would have to look more carefully at that issue. What I can say is that no such authority is conferred in the present ordinance.
Well, okay, I understand
If the
that.
board seeks to amend the ordinance in that fashion, I would have to evaluate it at that time. I simply have not done so.
Thank you.
I don't know whether I can formulate a question, but it seems if the debate is over jurisdiction and delegation to this commission, this is a kind of a simplistic way of looking at it, but could not the Board of Supervisors, if that is their intent, whether they did it, through this ordinance properly, if this whole discussion were being held before the Board of Supervisors, could they give some direction to the clerk's office? And if not, then obviously they can't delegate it to us.
That's a good question.
Well, under the ordinance as presently written, and this is the difficulty with the ordinance, this isn't a question that can be deferred to the Board of Supervisors because there's no appeal to the Board of Supervisors.
What I'm suggesting is that if the uncertainty is whether or not they had delegated it properly to this commission. What if we rolled the clock back? There was no ordinance. It was, or the ordinance was just simply that with the Board of Supervisors administering it. Would they have the authority to do this?
Would the board itself have the authority
Right.
to?
Yeah, because if the answer to that question is no, they wouldn't have the authority, then all the rest of this discussion as to whether they delegated it to us is sort of moot, isn't it?
I'll confess, Commissioner Johnson, I just don't know the answer to that question, not having looked at it. And I should note that the commission does not have to go to Government Code Section 31,000.1. We raised that issue, and we believe it's an independent ground why there is no jurisdiction. However, we believe the issue of jurisdiction is also properly resolved when looking at the express language of the ordinance, the legislative history of the ordinance, which makes it a crime for a person, which necessitates the conclusion that the office of the clerk is not a person. And thirdly, when one looks at the practical application, the parade of horribles, as Mr. Chairman referenced, that analysis, that statutory construction analysis itself answers the question, in our view, in the negative, that there is no jurisdiction over the office of the clerk under this ordinance, that the proper approach is the traditional method of mandamus, to seek to compel a public official or agency to perform a legal duty.
I'd like to hear from Mr. Wucher again concerning the issues that we've discussed.
Thank you.
Thank you.
Let me address this one point on, I think there are a couple of issues here. Obviously, there's a statutory interpretation issue and the references to the Political Reform Act and the definition of person and whether or not a violator equals a person. I think one of the points that Mr. Gilbert just made is absolutely correct, but it cuts against his argument, and that is that I think it's 83115 of the Government Code makes it quite clear that the FPPC has jurisdiction with respect to violations by any, and included in there is agency, which would specifically include city clerk, county clerk. And the problem is that in the very next section, that was added subsequent to the actual initial Political Reform Act, where they talk about the probable cause proceeding, that's where he gets this language that they use the phrase person in the same context where they're referring to violator, and therefore a violator has to be a person, they're synonymous, and it can't be a county clerk, because a person is defined, in his view, to not include county clerk, although you pointed out, the chairman, that there's some ambiguity in even what organization means and other groups of persons. But even let's take him for that it's true that person under the Political Reform Act definition does not include county clerk. He set up a complete inconsistency between 83115, which makes it clear that the commission does have jurisdiction over county clerks if they violate any provisions, And now he's adopting an interpretation, a violator, that says, no, it doesn't include county clerk, so therefore the commission wouldn't have jurisdiction. So the argument that he's making with respect to this commission's lack of jurisdiction over a county clerk, based upon a definition of person in the Political Reform Act equaling violator, would mean that the Fair Political Practice Commission itself would not have jurisdiction over a violation by a county clerk. But we know that that's clearly wrong, because it explicitly does, and we know that they've asserted that jurisdiction without objection. I actually also think that the argument that he makes with respect to the provision, I forget which number it is, about the criminal penalty that had been removed from the ordinance, about any person may be subject to misdemeanor, actually again cuts against his argument. If it is true that person definition does not support, it does not include county clerk, that makes perfect sense. Nobody is suggesting that the county clerk would be subject to a criminal action. But the ordinance does not use the phrase person with respect to who is subject to an administrative action. It talks about violator. Person comes into this through some completely, as I say, unrelated provision in the Political Reform Act that he kind of pulls and equates with violator. But this ordinance never says any person is subject to administrative action. It just talks about violations and violators. And as we submit, we can find no basis for concluding that a violation of a duty by the county clerk of the explicit duties under the ordinance is any different for that purpose than a violation by a campaign committee or a candidate or anything like that. They all are necessary for the ordinance to work. I do think, however, that there is a distinction between a arguable violation of a duty by somebody who is part of the enforcement mechanism, of the complaint process itself. One could say that's a little different than saying you have a duty under the ordinance that's substantive in nature to make it work. You're now part of the recipients of complaints, and yes, there's a bunch of things that are set forth in that process. I can see where somebody would make a distinction saying, well, that's not the same as saying, okay, we're going to say a violation of that is itself a violation of the ordinance. But even if it were, as you point out, to the extent it's a ministerial obligation, I don't understand why it would be a big problem for the commission to be able to say, if we've got an initial investigating attorney who hasn't been producing the reports within 30 days, that they order the person to produce reports within 30 days and say that's within the commission's jurisdiction? That seems appropriate to me, that would be something that the commission would want to do. If it's going to make the ordinance work and it's intended to pursue what the objectives were of the Board of Supervisors in passing it, I think it's fine. Let me get to the jurisdictional issue.
Excuse me, and impose a fine?
If the commission thought it were necessary, yeah. I mean, I think if somebody's being given a task and they're under circumstances for whatever it is that it's not justified, that they're sitting on these things, the California Supreme Court will impose fines on on attorneys who take death penalty appeals and don't file their briefs on time. They order them a couple times, and if they don't get that brief in, they will fine them. Sometimes that may be the only way to get compliance. I'm not suggesting that it would be appropriate in the vast majority or even any case, but I don't think you don't have the jurisdiction to do so necessarily. So let me turn to the jurisdiction issue because, look, this is an issue that I didn't initially address, and I confess that I have not only incomplete research on it based upon really reading what Mr. Guilford's submission was. It seemed a little beyond the scope of what I was asked initially, and I didn't realize it was something. But it does, of course, have real implications because, as I pointed out, and as I think Mr. Guilford agrees, their argument is unless there's a direct appeal from any decision of this commission to the Board of Supervisors, you can't impose any penalties. You can't impose a fine. You can't tell somebody to file a report. You can't tell somebody to stop making excessive contributions. And I just think that is a huge, huge leap from what exists all over the state, to my knowledge, about ethics commissions. Now, I haven't reviewed whether there's a substantial distinction between a city ethics commission for a charter city and their authority versus one from a general law county like this. But I do know that these are the kinds of tasks that are routinely granted without rights of appeal to the underlying governmental agency, the Board of Supervisors or the city councils. The language on which all of this supposed lack of jurisdiction comes from is that government code section, which doesn't, I mean, it's written in the positive, you know. It says, the language is that the Board of Supervisors may appoint commissions or committees of citizens to study problems of general or special interest to the board and to make reports and recommendations to the board. It's an explicit grant of authority to do that. It doesn't say they can't do any more than that, and the AG's opinion cites a case which makes it clear that not only can they make recommendations, but that they are also authorized, and let me get the exact language that the AG opinion used, but it's something to the extent of performing administrative functions for the board. So that the Board of Supervisors is authorized to delegate administrative functions to another body, and therefore they conclude, on page 3 of the opinion, in light of these authorities, we perceive no barrier to a county establishing a campaign finance ethics commission to adjudicate complaints and to assess fines and penalties for the purpose of enforcing the county's campaign finance ordinances. I don't read that language as saying that the law is invalid. I will point out that the language, the sentence that Mr. Guilford read to you about, that this particular thing does not include provisions for oversight, was followed by the very next sentence, which he didn't read, which says, although we are not in a position to declare the ordinance unlawful merely because it is silent on those points. So clearly the AG was saying, look, we're not looking into this thing, and we're not going to say just because we haven't seen anything in there that addresses this issue that it's unconstitutional or it's an illegal delegation. But, this is something you need to think about, you need to be careful about. And I do think that subsequently, when the board supervisors amended the ordinance, they included a number of provisions that make it clear that there's this oversight about what the commission can do, and they dealt with the appointment issues and things like that. So again, I don't think it's a rule of law that every single decision from this commission has to be appealable to the Board of Supervisors, or the commission lacks the authority to have that authority delegated, to have that delegated to them. I think that's a real extension of the statutory language on which the argument is based, and certainly an extension of what the Attorney General said. So that's my responses, I think, to what thing that again, specific questions I'm more than happy to address.
Thank you. Further questions? Okay. We need to hear from anybody else in connection with that matter. I have no additional speaker cards. What's the pleasure of the commission, how we proceed at this point? A comment. I think we have some threshold issues yet to encounter with respect to what action we can take today. I think it was useful to have the discussion about the jurisdiction of the commission and its apparent limitations. And it was useful to have the discussion for purposes of informing the Board of Supervisors about what concerns there are with the present existing ordinance. However, the matter that is before us today under Agenda Item 13 is really much more limited. The Item 13 deals only with P212-10 allegation number 5. Allegation number 5 names the respondent as Mark Lunn, County Clerk Recorder. We had discussions previously in previous sessions about the availability of amendment should the entity be found to be inappropriate for enforcement under the ordinance. the entity, the individual, the Recorder Lund. I don't believe that Mr. Bennett has availed himself of the opportunity to amend the complaint, or allegation 5 of the complaint, to allege the office of the clerk recorder. And so it appears to be in agreement, through my understanding, that we're only dealing with the named elected recorder in today's proceeding, and that the parties are essentially in agreement, and I concur, that the commission has no jurisdiction over Mr. Lund. I'll hear from you in a minute, Mr. Bennett. So that raises a couple of issues for me. First of all, I don't think that we can take any particular action with respect to making findings about whether or not the commission has jurisdiction over the office of the recorder. That matter's not before us today, I don't think. The commission, as a quasi-judicial body, isn't in the business of giving advisory opinions or opining upon things not fairly presented to them for decision. I believe that the remedy of amendment may still be available to Mr. Bennett. There's a 3-year statute of limitations on filing complaints from the date of the violation. It's not before us, nor could it be before us today under Section 1305 of the Operating Procedures, which provides that upon motion, the commission may allow amendment of a complaint or dismissal of all or part of a complaint, except when submitted by stipulation signed by all the parties. Notice of a motion brought pursuant to this section, along with all moving papers and evidence, shall be filed with the commission and served on all parties at least 14 calendar days before the regularly scheduled meeting of the commission at which the motions will be heard. I think it's a given that we haven't received that component. That's not to say, again, that a new complaint could not be filed against the office, but I don't think it's fairly before us. Although we're through with the public comments, I would invite Mr. Bennett to respond to his inaction in amending the complaint.
Thank you very much, Mr. Chairman C. Certainly when I left the hearing two meetings ago, I was under the impression that you were asking for all of this because I believe the language was used. You wanted to make a determination whether you even had the authority to do a review of the clerk's office. We were at that point in time. I had mentioned that I would certainly be willing to amend, but it seemed to be a use of resources. For example, if I'd filed the amendment, the initial review attorney would have to do something, investigating attorney would have to do something with that. So I was operating on the assumption that you wanted to hear these arguments so you could determine whether you felt that you had the authority to even hear it. If that is in fact the case, I would then make the decision in terms of amending for the clerk's office to try to move forward. So one of the actions that I assumed is very possible is dismissal with the right to amend still to stand forward. But it would be helpful after hearing all of this testimony. I think that the public was left with the impression that the commission was going to weigh in. I agree with you that it's not really certain whether the commission only had to entertain this question because it was raised by Mr. Lund that he contended he was not subject to an administrative hearing by this commission. There's a difference between that and direction to the Board of Supervisors that you shall or you shall not include the clerk in the ordinance. That's something that the Board of Supervisors will entertain with the advice from County Council, I believe, as we go to try to amend. But so there's a little bit of a chicken and egg or question here, but the issue of amending and do we want to go through all of that, I think is a question that seemed appropriate to wait and hear these arguments and hear at least the commissioner's response, even if it's just a verbal response. I would finally offer to you the bigger issues are these in my mind. I'm less concerned about what happens with the clerk regarding the past things. I'm much more concerned about where we go in the future. And I think that what we would all like to do with campaign finance law is this broad. We'd like it to be really tight, and I think most people in the public would really like to decrease the influence of money in politics. What we are legally allowed to do is a very narrow funnel, and we are trying, I think, very hard to craft an ordinance that allows us to get the maximum gain and get it through this fairly narrow legal ordinance out there. Those people that are opposed to campaign finance reform will always try to decrease the authority of campaign ethics commissioners. They will always try to decrease the authority of the Board of Supervisors to legislate in this realm. And what I implore you to do is to make sure that you do what I believe you accepted positions on this for, and that is to be the public's advocate, to try to stand for as thorough, as good, as strong of a campaign finance reform as we can possibly have here in Ventura County. And that means to keep your authority as strong as it legally can be, to keep the Board of Supervisors' authority as strong as it legally can be, and to recognize, because of the complexity of the law, that we have to identify specific duties for different people. And we're trying to craft the best that we can from all the local ordinances that are out there. And many of these local ordinances do call for duties of the clerk, many of these local ordinances. So it's the big picture. If we have to change a small phrase in the ordinance, if the complaint has to be amended, and I ask myself, do we do that and go through all of that to again entertain the question of whether the clerk, it would certainly be helpful to have a general idea of your sense and at the same time respect the fact that the board can make those modifications. I hope that helps clarify, but I believe I did state last time that I'm willing to amend any and all of the complaints that I submitted, but it seemed prudent and most appropriate and efficient from the commission standpoint for me not to send 2 more attorneys through those things until I hear that. Thank you very much.
Thank you.
I just consulted my notes from that meeting, and each of the members of the commission voiced their concern at that meeting over whether or not the commission had jurisdiction over the clerk as an individual, not the office. And the continuance was granted to have that issue examined. Now, I think it's marvelous that not only was that issue examined, and everybody agrees that we do not have jurisdiction over the clerk individually, but now we have this marvelous analysis of our actual jurisdiction, total jurisdiction over the clerk as an office. And I think that Mr. Wucher may have made the most brilliant statement of all when he said that reasonable minds may differ on this issue. And reasonable minds do differ. If this were a court, we would accept the motion to dismiss or the demur because the plaintiffs or the defendant's the wrong party. And I think that's what we have to do. I would suggest that the county, maybe the board, take a look at this issue and see if there is a way to amend the ordinance to make it clear if that's a question. Whatever else can be done so that we have a clear view of the board's intent when we act. And then whatever you give us, we'll act on.
Yes. Why not?
Thank you, Mr. Chairman.
Briefly.
Very briefly, just as a procedural matter, in response to Mr. Bennett, if the complaint is dismissed for no jurisdiction over Mr. Lund in his individual capacity, I don't believe it would be proper in that circumstance to dismiss it without prejudice, since there is no circumstance under which it can be amended as against Mr. Lund. To the extent that there's still time under the statute of limitations, should Mr. Bennett decide to pursue a new complaint against the office of the clerk, that would be a new complaint, not an amendment to a complaint against Mr. Lund in his individual capacity.
Thank you.
Thank you. All right. What's the pleasure of the commission? There is no recommended action before it. I would solicit a motion with respect to allegation number 5 alone. Yeah, before we do that, let me just express to Supervisor Bennett and everybody else, really, it is tempting to reach out to the issue of jurisdiction, its limits and parameters and so forth. But I don't think we can do that. I just don't think it's appropriate under the current posture of the proceedings here. I do think that enough has been given to the public and to the Board of Supervisors to reach a conclusion in their minds about what the scope of the jurisdiction is likely to be and what changes could be made to make that explicit, and then subject to judicial review if necessary. But I share your concern. I just don't feel comfortable issuing advisory opinions about what the commission would do if that question were properly presented to it. So. Gentlemen?
Well said.
Well, I would move to dismiss allegation 5 of P 2012-10.
Without prejudice.
You know, I don't know that that's
Well, that doesn't
necessary.
matter. It's not going to be brought back, so. With prejudice, I guess it would be.
Well, certainly with the expressed intent that it not be a bar to the filing of a complaint against a different entity, to wit the clerk of the board, the office of the clerk of the board. That's my motion.
I'll second it for purpose of discussion.
Okay.
We've heard all of this testimony. We've received all this material. These are tough issues and important issues. And do we want to include a recommendation that maybe the board look at this? Or do we just, they already have our feelings on it, do we leave it at that? You're the expert on this, Johnny.
I think you overstate that. It seems what I'm getting out of all this, trying to sort through the Latin for lawyers and the legal reasoning, is that everybody sort of agrees, at least I agree, that we have no jurisdiction at this level over a constitutional officer who's elected by the public, and that's not really the issue at this point. It seemed like everybody was kind of, do what? No?
I think right now what we're saying is that we have no jurisdiction over an individual who serves as the county clerk.
Right, and I'm speaking of the individually
Not
elected officer.
not as the elected officer in the office of county clerk.
Okay, I think that distinction may be escaping me, but
Well, the complaint was filed against Mr. Lund individually,
right. And there
not
was
as the county clerk in his official capacity. That complaint's, the motion is to dismiss that complaint.
Okay.
If the complaint,
Even if it were, I mean, would he be refiled?
it could be refiled against
Lund
the
as
office of the
clerk?
county clerk, yes, official
Okay,
capacity.
when we say the office of, not as the officer.
Right, in his official
Yeah,
capacity. as the county
I'm making a distinction between the person that we elect to run the agency and the agency. I don't know what the right legal terminology would be. But I'm just saying that it seems like everybody kind of agrees that you don't single out that individual. And even if we did, under the Tort Claims Act, that unless there's maliciousness, fraud, and I don't know what the other conditions are, that public officers, whether they're appointed or elected, are not held, because of the chilling effect on them carrying out their duties, that they cannot be personally attached, from the complaint. So it's not about the fines. Okay. So seems to me that the policy concern expressed by Mr. Bennett was the concern about nullification of the process and the goal, which is to reduce the influence of money in politics. And most everybody I talk to, personally as well as publicly, all agree that that's a great goal to achieve, and it always gets down to how do you achieve it. And I've said this before in these meetings with the Citizens United decision of the Supreme Court and equating money and speech. Those are issues that are far beyond this commission. But the question I keep coming back to, based on the request of Mr. Bennett, which is some kind of guidance so as not to just keep churning this thing with more complaints and more investigations. And I come up with, so if it's not a penalty, a fine, whether it's legal or not, but it doesn't seem to be practical to levy fines against the taxpayers in effect, what is the remedy available to us or to the policymakers to dissuade or to protect against the potential for nullification? And it seems like it gets down to specific facts of a specific complaint related to the practicalities of time to meet the reporting deadlines and the economic realities of resource, because sometimes if you put on 5 shifts, you can actually accomplish something to no profit. So how much goes into this? To me, it gets back to the practicality of the timeline. Is it possible to achieve what we're trying, or the Board of Supervisors is trying to achieve within the time frames that are, or the constraints on during an election? And I don't know the answer to that. It does seem like it could be tightened up a bit, and maybe that would be helpful. But ultimately, it gets down to the court of public opinion in elections as to whether or not those people in office are doing their job and doing it properly. And I don't see how we can do much about that. I mean, that's just kind of a very broad, general, not specifically. I do not see us having jurisdiction over the clerk or the individual, Mr. Lund. So I'm not sure. It's a conundrum. I don't know how we work around that. We don't do it by singling out individuals and trying to penalize them as administrators at this level, it appears. So we need to come up with a better idea.
It seems to me that we have resolved an important issue, and that is the county in particular is operated and governed by a variety of different officials. Some are appointed to particular positions, some are elected to particular offices, and there are differences, operational differences, responsibility differences between an appointed department head or functionary and an elected. And we are recognizing that an elected is not subject to direction and control by the Board of Supervisors in some areas. The political remedy of an election every 4 years is the only remedy against a non-performing elected official. But that does not mean that the county and the Board of Supervisors cannot order its various entities, including those captained by an elected official, to do various things. What those things are depends upon the office or the function. For example, the district attorney operates pretty much independently from guidance, direction, and control from the Board of Supervisors, other than over his budget. But other electeds, the auditor controller, arguably the clerk recorder, may be subject to the imposition of certain ministerial duties, which the office must perform, but the officer, the elected, cannot be directed to do individually. And so I think that's the distinction we've made, and we're satisfied that basically Mr. Lund is not an appropriate respondent in this matter, and that was the reason for my motion to dismiss. I would observe that whether or not the clerk of the board is subject to the Board of Supervisors, I was struck by the analogy between the Political Reform Act and control over filing officers under that act, and Mr. Woocher's analysis of whether or not that applied to the clerk of the board, but such a final determination isn't before us, and I won't make it. So that's why I moved to dismiss the matter.
Well, I'm going to support the motion, but I have a document dated April 16th from the clerk recorder, and I have not studied it, nor do I know if I had studied it, whether I could evaluate it. But it is titled, "The Summary of Campaign Finance Reporting and Monitoring Enhancements in the County Clerk's Office Since 2010, and I think it is suggesting that they are doing the best they can to tighten it up. Now that, I guess, comes down to reasonable minds may differ, but at least that seems to be part of what has come out of all these proceedings, is that everybody's trying to make it more effective.
I want to take that up as 8A as soon as we finish 13.
Okay.
Move for the question.
All in favor?
Aye.
Aye. All opposed? None. All right, that disposes of 13. Let's go back and pick up 8A, which I neglected to take formal action on. 8A is the receive and file agenda modification, receiving Mr. Lund's letter and its attachments. Do I have a motion?
I move.
Second.
Any opposition? Hearing none, that is received and filed. Now, we're back then to...
H is receive and file the County Campaign Finance Ethics Commission's fiscal report.
Right. I added an 8A in agenda review to add an additional receive and file item. I labeled it 8A. It doesn't appear on the agenda. We amended it. All right. I haven't screwed this up fairly well.
Doing great.
Did we finish 9? We did. Oh, no, we put
No.
over 9. What were the rest
No,
of them?
we finished 9.
All right, 9 I'm sorry?
We're on 10, 11.
We're finally through with 9?
We finalized
Okay.
9.
10 and 11 we were handling together, and I thought there was a request for 9 to delay it until after the hearing on the 13th, but that's fine.
But we didn't technically do that. So.
Okay. 10 and 11, we've had the presentation. The recommended action is to approve the settlement. What is the pleasure of the commission?
I move we approve.
Second.
I'll second that motion.
Oh,
Excuse me.
any discussion?
Well, this was delayed because there was a suggestion that maybe the legal analysis provided to us would somehow affect our ability to, or our jurisdiction to accept this kind of a monetary settlement. And I don't think that we've heard anything today that would affect our jurisdiction over these two matters.
I agree. Okay, so 10 and 11, the motion is to approve. And seconded. No objections?
Objections.
All right. Item number 12, alleges firefighters for a better government. in P 2012-5 and 2012-9.
Thank you, Mr. Chairman, members of the commission. This is a stipulation to resolve two cases, again, involving independent expenditures, which were made in expenditures that were in excess of $1,000 each and not timely reported within 24 hours on Form 1275 as required by the county ordinance. There were 6 independent expenditures in question. The 6 are detailed in the staff report. One sort of unique twist to this case is that the reporting requirement for the 6th took place at a time simultaneously with the committee's filing of a statement of organization that became a state committee as opposed to a county committee. And at the point at which they became a state committee under Government Code Section 81009.5B, the county's local filing requirement did not apply to them anymore because the government code says that it doesn't, and I'll be happy to go into that further if you desire. We had that circumstance come up previously in a case a couple of years ago, same situation where a state filing committee was not required to comply with the local additional filing requirement and dismissed a violation in that case. So in this case, I have proposed a fine for the 5 expenditures that took place before they became a state committee at $1,000 apiece, and did not propose a fine for the 6th, which was not required to be reported. That's consistent with the independent expenditure case that you approved 2 meetings ago at $1,000 per expenditure that was not timely reported. And so that's the reason for the $5,000 that's proposed.
I had a question in connection with that. What was the filing status of the firefighters prior to August 10th, 2012?
Effectively, they were a county committee that had not yet filed. Once they filed their statement of organization on August the 10th, they became a state committee and reported activity outside of the county of Ventura. That's why they became a state committee on that date, is because they had activity in other counties.
So they hadn't filed a Form 410 prior to August 10th?
They filed their initial Form 410 on August 10th.
Okay. And it is the filing of that form which confers immunity from the local control, is that right?
That's correct.
Notwithstanding the fact that they were engaged in statewide activities prior to the filing of that form.
That's correct. The 410 is what gives everybody notice that they are a state committee, and that's their contention, and I agree with that contention as well.
Very well. Any questions? What's the pleasure of the commission?
Move recommended action.
Second.
Okay, it's been moved and seconded. Is there any opposition to the motion? Hearing none, it is approved.
Thank you.
Thank you. Okay, that should do it, except I took up your name. Is there any further business to come before the commission at this time? Then we stand adjourned. How would you like to be chair next year? Thank you. No.